Hello, everybody. Happy 4th of July, Independence Day. I'm so excited. A Daystream Live. And I am wearing my shirt from C-Rex. It's one of the first shirts she bought me. I think it might be the first shirt she bought me. And she picked out just the most beautiful one. I love it so much. Hi, Ava. Oh, yeah. Yup. Took you a minute to realize what was going on, huh? Yeah, you're not used to this daytime stuff. Oh, yeah. Yep. Oh, my gosh. I'm not used to there being sunshine when I open that. Oh, hello, sweet C-Rex, my love. Good to see you. Hello, Catherine Gaston. I am so happy to have you guys here. Mortimer Duke. Yeah, she added the L on. And she mentions her new name. She doesn't ever outright come out and say that she's Moorish or sovereign. But, I mean, the clues are there. You know, I mean... I love it. That doesn't fuzz me. Oh, you guys are so punny. I love you. Oh, gosh. Yes, this is going to be so great. I wanted to come on earlier, but this actually, it quite literally took over 5 hours to edit it because the audio and video were not in sync for the February hearing. Yeah, I had to go all the way back to February. There was a, I don't know, some kind of issue with YouTube and the download program that I use and everything like that. So it kicked the audio and video out of sync, and I had to go through and like each space I had to do a lot more than usual, but it's so worth it. It's so great. I'm happy. Absolutely. Yes. All right, guys, let's have some fun.
All right, good afternoon. The 14B District Court is back in session. The court will call the case of Portfolio Recovery Associates LLC versus Shatina Grady. Case number 24C2622.
Good afternoon, Your Honor. Thomas Duquette, P82958 on behalf of the plaintiff.
Good afternoon. Ms. Grady L., please unmute your device and state your name. You're still muted.
Shatina Grady L.
Thank you so very much. All right, today is the day and time that is scheduled for a motion for summary disposition.
Yes,
But the pre-trial is not until March 6th. So today's the motion for summary disposition. Ms. Grady L., I presume that you have received that, since I did receive a response from you.
I did receive it, and I did put in a response approximately 2+ weeks ago.
That's why I just said I presume you received it, since I got
Oh,
your...
yes.
Okay,
Yes.
thank you. All right, are we all ready to argue this, or do the parties want to talk and see if they can reach some resolution?
No, I think we're ready to go forward with the motion.
Ms. Grady-L?
Yes, we can go ahead with the motion.
All right, and you understand if you don't win this motion today and they win the motion, that they can then get a judgment and start collecting against any proceeds that you receive in terms of income, Ms. Grady-L?
Yes, I had at our initial court, if I could speak. I don't know, am I able to speak?
You'll get a chance to speak if you want to go forward with the motion. Correct. I'm just asking whether you understand that if you don't win, that's what the result is going to be.
Yes,
Okay, thank you. All right, and you want to go forward with the motion with that
yes.
understanding? Okay, thank you.
Well, for
Mr.
trials, I mean, to see if we'd be going to trial. Is
It
that
may
what
or may not go to trial if the motion today is for them to actually win the case. They're saying you don't have a defense. And the court will be looking at whether or not there is a valid defense to this. And if I
Okay.
find that there is not a valid defense, then they are going to win their motion for summary disposition. And then what happens is they get a judgment and there will be no trial.
So I'd have to figure out if I want to go ahead with the trial instead, or yes, I'm okay with the summary disposition. Yes.
Well, if you have the motion for summary disposition and they win, the case is over. They get a judgment against you and they go and they try to collect on that judgment.
Okay.
Okay? With that understanding, you still want to go forward with the motion. You don't want to talk to them today.
Yes.
Okay,
I want to go for it.
all right. Mr. Duquette, you may proceed with your motion. Please try to keep it as layperson as possible so she can understand what your arguments are.
Sure thing. This plaintiff's motion for summary disposition under MCR 2.116 C9 and C10. Those are two court rules that serve as the basis for a motion for summary disposition. C9 says that the defendant has no valid defense, and for that reason, summary disposition is appropriate. That's the argument we're making with our motion. While defendant has raised several standard affirmative defenses in both her answer to the complaint and answer to the motion, plaintiff doesn't believe any of those defenses have legal merit. For that reason, we think summary disposition is appropriate under C9. C10 is the second court rule that
I think you have to address her. I'm going to need you to address her actual responses so that you say you don't think they have any merit, but you need to actually address them to make a record.
Sure thing, Your Honor. There's a long list of them, which is why I, for briefity, was trying to.
I have to rule on each one of them, so.
Sure thing. Let me just locate the response to the motion. Defendant lists 11 affirmative defenses. We'll start with number one. She says that the plaintiff hasn't provided a contract between her and plaintiff. That's not true based on the evidence attached to the motion. This is an action to recover the balance on an unpaid credit card account. Defendant can affirm a contractual relationship with my client by utilizing the credit card that was presented to her. She did in fact do that. She used the credit card to make purchases, made some payments, but eventually stopped making payment, and that forms as the basis for this breach of contract. An account stated complaint serves as a ground for plaintiff to recover the amount it's seeking as damages. The second,
you can stop right there. So what you said was that essentially the law allows for the credit card debt to be affirmed through use of the credit card, correct?
correct.
All right, thank you. Your response to that, Ms. Grady?
The plaintiff has not shown a valid contract between Shatina Grady nor Shatina Grady L. And I have requested that they send.
Ms. Grady L, did you hear his response? And he's correct about the law. The law allows for it to be a contract when the actual credit card is used. That is the law. So.
But they're not the original creditor.
They don't have to be.
As a second party creditor or collector, I have not given anybody any permissions to access my private records or the records of Shatina Grady. And there's no valid contract with them. That
All right.
the information that they sent over to me does not have a complete account number. It does
It
not
does.
have,
It's right there on the document, ma'am. I looked at it myself.
I don't have that one in front of me, but I didn't see a complete, I did not see a complete,
The account number, do you want me to say that in the record? Because it's right here in this file.
yes, the complete one.
609-1925-0991-8422. It's right in the documents, ma'am.
I looked high and low for the complete number. It did, I know they said they purchased this debt from an original creditor, but it does not have all of that information on there. There's no accountment stating, I have disputed this balance
Ma'am, I'm just
previously.
dealing with the first one, which is that you're saying that there is no contract. And he's telling you that the law provides that if the card is used, that does account for the contract.
But is that a contract between Portfolio Recovery or the original creditor?
You don't have to have, okay, thank you. All right. As to defense number one, the law provides that a second party, third party, fourth party, however many, can actually buy the debt of an original creditor. The debt doesn't have to have a contract between the debtor and the creditor, the second, third, fourth, or fifth, however many numbers they transfer it to. All right, number
But
two,
there's no, okay, go ahead.
defense number two.
Defense number two indicates the plaintiff has not provided any document authorizing the handling of her personal data. I'm not sure what document she's after here. In any event, that wouldn't serve as a valid defense to her liability on the underlying debt. Paragraph number three, unless the court wants defendant to specifically address.
I'm gonna know did you hear his response to number two? And we're going down them one at a time. So please stick to
Document this, anything that from the original creditor that I have allowed for them to send this information to a third or fourth party creditor. The track, like, I just can't track it. There's been I have originally, before this point, made an inquiry with the original creditor, as far as what the balance is. There's no correct accountant of statement that is telling me what the debits were, what the starting balance was, what all the interest that has occurred. It's not showing. It didn't show me all of the account statements.
right. As to number two, plaintiff has not provided any document authorizing the handling of defendant's personal data. Once the debt is established, the law provides that the creditor can transfer that. They don't have to have permission of the debtor to do so.
Is that under the Fair Debt Collection Act practices?
Ma'am, we're in the state of Michigan, first of all, and that is what the law is in the state of Michigan.
Which law is that?
I don't have the exact MCL, and I don't have to provide that, but that is what the law provides. All right, number three.
Number three indicates that plaintiff has not provided a complete account number for defendant to review the alleged debt based on the evidence that plaintiff has put before the court and the court's reflection of that evidence. That's not correct. Plaintiff has provided the full account number.
Radio.
I'm looking at my record. I'm almost there.
While she's looking for that, Mr. Duquette, when you provide your order, I'm going to need you to address her particular responses. And you should cite the law on number 2, whatever that MCL is, for transferring of the debt.
You said this should be in plaintiff's order granting the motion?
That's what I said, yes.
Okay, understood.
Are you granting the motion for disposition?
Well, I'm denying these 2 so far, so he's going to put that in the order. We're not done. We apparently have 8 more to go.
10. She submitted 10. They've gotten through 2 of them. This is so much fun.
Yeah. I don't know why it's not coming up. Hold on 1 second. I have to click. Okay, what page were we on for the account number?
You look at Exhibit B.
Exhibit B. Okay, so Exhibit B. Okay, Exhibit B.
First page.
Oh, that would be, is this like it on the statement? Is that what we're looking at?
Yes, it is. You look right down at the bottom where it says Art Van, right above your address. If you look at the minimum payments, past due, payment amount, new balance, and account number.
There's no, it says it says 8422. That's what I see.
I'm not sure what you're referring to, ma'am. Did you look at the bottom of the page of page 1 of Exhibit B?
Yes, page 1. It's an Art Van statement. I'm at the bottom. At the bottom in those boxes,
Do you see
it says,
payment? No, ma'am, stop, please. Do you see payment enclosed?
yes,
You see right above that?
yes,
You see the minimum number,
yep,
past due amount,
yep,
payment date,
yep,
new balance,
yep.
then account number.
Yes, it is blacked out and it says 8422 by my records that was submitted to me for my review.
Did you black that out, Mr. Duquette?
It would have been redacted in anything that we entered into the court file as its
Well, then
PPI.
you guys sent it to the wrong places, because I have the one that is not blacked out. Because it's clearly here in mine. I just read it to her.
Yeah, that could have been missed. But if it was blacked out in the copy that we sent to her, obviously it should have been blacked out in the copy that was provided to the court.
Okay.
In any event, that is the full account number, and there's no
She doesn't have
reading
it.
that.
Her argument is she doesn't have it.
If the court would like, we can supplement the brief and send her an unredacted copy.
Thank you. We're gonna need to do that, and the court file is going to need to have this information removed from it. All right, and then number 4.
What did we do for number 3? What was the answer for that one?
They're going to amend their pleading to provide you with the proper documentation, ma'am.
Number 4 indicates the plaintiff has not provided a full accounting of the alleged debt for the amount of $2,296.97. Based on the evidence in the court file, this is inaccurate. Attached as Exhibit B is an account statement, the final account statement when the account was charged off, which indicates that the total balance due and owing is $2,296.97.
Ms.
So in
Grady,
the top left-hand corner where it says previous balance.
Ms. Grady,
Yes.
response, please.
Okay, so I can't verify that amount as being correct if I haven't received all of the accountment of statings. Like I need to have all of the payments, the credits, the interest rate, like any disputes, which I will say that this was disputed on a credit before. So I don't know I don't know if this balance is correct.
When you say
They
these,
have, go
go
ahead,
ahead.
go ahead.
Go ahead, I'm sorry.
Oh, I was just saying, I'm just looking for, I don't have the correct numbers in front of me. I don't feel, because I don't feel that this is the correct amount.
When you say these were disputed on a credit, what do you mean by that? I don't understand that particular statement.
Just with the original creditor, if this account balance was correct.
You disputed the balance with the original creditors? Is that what you just said?
Through TransUnion, yes.
Just a dispute with the credit reporting agency, Your Honor, that actually isn't directly with the original creditor. Moreover, she received each account statement at the current address that she's listed on both her answer to the complaint and answer to the motion. She has every single account statement that would itemize every single transaction on this card.
So do you know if those were used with a signature or a pen or
No,
PIN
they're
number?
They don't have to produce that, ma'am. The law doesn't require they produce that. The, Mr. Duquette, when was this account established?
Yeah, I do not know the opening date off the top of my head, Your Honor. I'd have to search through the statements to find it.
It appears that the first statement that has been provided here was, starts with a previous balance of 1766.53. Do we agree on that, Mr. Duquette? 1766.53.
What's the closing date on that statement?
August 23rd, 2019.
Yes, I would agree with that.
Thank you. Do you agree with that, Ms. Gradiel?
I don't know.
You don't know what you received? That's all I'm asking you about.
Let me see. So you're asking me if that's what's in the document.
Correct.
Which page of the Exhibit B are you looking at?
I don't think they're page numbered like that. It's the last page of the exhibit. I guess it's the best way to try to tell you. Before you get to Exhibit C. Well, it's not the last page. It's the second to the last page, which is the last statement. Start.
Last page. I don't exactly see where.
Second to the last page, ma'am.
So where it's in Exhibit B, the first, second. No.
Your Honor, if the court prefers, I could supplement our motion and respond to each individual paragraph in her motion to dismiss. I could cite the applicable law and state our arguments.
I think that's the best way to handle this.
Yeah,
She's not just trying to respond off the cuff. And I think that's the best way to handle this.
and be happy to do that if the court can give us maybe 30 days out for the next hearing. I will get that to her as soon as possible.
All right. Ms. Gradiel, do you understand what we're saying, ma'am?
I believe so.
He's going to respond to each of your responses, defenses, and outline this in a manner in which you understand what the law is, and you can review it for yourself and make any arguments based on that. Okay?
Okay. Okay.
Can you, does March 20th work with everyone's calendar?
Yes, that would work for plaintiff.
March 20th. Yes.
All right, Madam Recorder, can you tell me what time on March 20th would work best?
2, 3 p.m. around the same time.
Oh, thank you. I appreciate that, but I was actually asking my
Oh,
clerk.
I'm sorry. Apologies.
Let's make it at 2:45 p.m.
Understood. Thank you, Your Honor.
Thank you.
Thank you. Thank
Bye-bye.
you. Bye-bye.
All right, the 14B District Court is back in session. The court will call the case of Portfolio Recovery Associates versus Shatina Grady, case number 24C 2622.
Good afternoon, Your Honor. Jeffrey Beers, P 41693 on behalf of plaintiff portfolio.
Good afternoon. Ma'am, could you please state your name?
Shatina Grady L.
Thank you. All right, we're here today on an adjourned motion for summary disposition. We began this process the last time we were here, which was on February 13th, 2025. I adjourned it so that plaintiff's counsel will have an opportunity to respond to each one of Ms. Grady L's allegations and in the counter complaint, as well as to the motion for summary disposition. Ms. Grady L, did you receive those responses?
I did not.
Mr. Beers?
They were sent FedEx. Let me check the FedEx number. It was sent FedEx on March 11th, and I have the FedEx tracking number. It's 772635809259.
I have not received anything. Have you? I don't know if you received something back saying that I received it, but I have not received anything. I received a text on my way out of town that FedEx tried to deliver something, but I was out of town until Tuesday. So I'm not for sure where the 11th would come from. The day I went out of town, I think what's the 13th? Let me look. Do you have the confirmation on when it was delivered, like the actual confirmation?
It'll take me a while to pull that up.
I appreciate it if you would, because I have not received anything, and this is speaking honestly and factual. I have not received anything. I received a text from FedEx the day that I was going out of town.
All right, Ms. Grady L, thank you. Mr. Beers, are you looking to see if you can have some confirmation of receipt or something?
Oh, and that
I'm
was
looking-
it was the 13th.
The 13th.
I'm looking it up right now. I wasn't.
All right, thank you.
Yeah. Says it was delivered Thursday, March 20th at 12:02 p.m.
So that's today, first of all.
And I just got home, so I wouldn't know if it's here or not. I just got home.
So if she needs more time to review, we can adjourn if the court would like.
I think that's what we need to do. April 17th, work with everyone's calendar.
Yes, April 17th is good.
I
All right.
just take a second to make sure it is delivered. If he's saying
Okay.
it's
All right.
1 second.
right.
Let me look.
Why is her bench wrapped in plastic?
Okay. I just want to check there's no delivery. And these is what I did have off of the door yesterday. They tried to deliver the 15th, the 13th, and I don't know when this one is supposed to be, because this one doesn't have a day on it. But as I stated, I was out of town.
Not really their problem. Had you been in town, you would have been there to receive the FedEx that they sent you, and you would have had time to review it. They really didn't bungle that one, though they bungled quite a bit.
I was in Missouri.
All right, so maybe you should try to do regular mail and maybe an email
I can email it.
Do you have an email you're willing to give him, Ms. Grady-L?
I think I'd like to just have it in the mail with
Okay.
the regular mail.
Is your address still 27?
Good afternoon. The 14B District Court is back in session. The court will call the case of Portfolio Recovery Associates LLC versus Shatina Grady, also known as Shatina Grady-L.
Good afternoon, Your Honor. Daniel Best, P58501 on behalf of plaintiff, Portfolio Recovery.
Good afternoon. I should have also said case number 24C2622GC. Ma'am, could you state your name?
Shatina Grady L.
Thank you. All right, we're here today on these motions for summary disposition, cross motions again, as well as now Ms. Grady-L has filed a motion for arbitration. I think we should start with the threshold matter of the motion for arbitration. Her claim is obviously that it is something that she's entitled to and that the court doesn't have any discretion in allowing her to have that. The response file, which I have reviewed, argues essentially that she waived that particular right when she chose to go down the route of filing for a jury demand and having multiple hearings regarding this matter prior to filing for the motion for arbitration. So Ms. Grady-L, it's your motion. I'll let you make any additional arguments that you want to make regarding that.
Okay, I never received the answer to this motion to compel arbitration either. I just would like to let the court be aware of that. I don't understand what is the reason that Portfolio Recovery and their associates tend not to send me information according to this case when they're supposed to send it. And to me, that is very deceitful. They are hiding something, and I am compelling the court to send this to arbitration because they also have, for the public record, defamed my character, Shatina Grady-L, by making false statements. They have said just recently in their response that I have not seen that you said that I shouldn't be allowed to go forward with this because I have asked for a jury. That is incorrect. I have not filed to have a jury. I asked about that before
Okay.
So like this Portfolio Recovery is a very deceitful, and their associates is being very deceitful in this case.
So my notes in the file from the magistrate when you met with the magistrate was the defendant requested a jury trial. So that is.
I did speak with her about that. I asked if I could, and she said she did not know. She had to check. And if you needed to run back the tapes, that's exactly what happened, because I did not file any paperwork for that. But I asked when I spoke with her, and she said, I don't know.
Okay. Well, the bigger piece is that there have been multiple hearings on this matter and that you have not filed any. Well, I'll let him make his argument. Mr. Best?
Thank you, Your Honor. As detailed in our reply, we believe the defendant has waived the right to arbitration in this matter. I mean, this is the third hearing we've had on our motion for summary disposition and the related motions. This matter was filed in October of last year, November of last year. It's now May. We are in heavy litigation. Numerous pretrials have been held. Numerous hearings have been held. Quite simply, the ship has sailed on arbitration.
And I would like to dispute that because according to you, you are saying that numerous ships have sailed, but your firm in handling this case has not handled it correctly. So you yourself have filed as Exhibit A something that speaks of arbitration, correct? So you are in knowledge that there should have been arbitration before bringing it to court. You did not. You did not.
We made no such acknowledgement, ma'am.
Didn't make no acknowledgement.
And we have not been deceitful. I find that offensive.
in your Exhibit A, it distinctly says that any one who comes and takes said debt that you said you were assigned, you are held to the agreements of Synchrony Bank that there is to be an arbitration first before seeking to court. Now,
That
in
is
my
correct.
opinion, that is not
You
my
need to read the statement. You need to read the agreement.
The law is the law. I did read it. I have it in Exhibit A. Look at Exhibit A. Because I don't have a contract, neither does the defendant with you. And so your company has repeatedly failed to answer these motions or anything with the information that I have requested. And
The defendant, wait. I don't have a contract, neither does the defendant. She's separating herself. It's the Moorish logic. I just had to point that out because it's very subtle. All of the things that she does that, makes me know that she's a Moorish sovereign citizen, they're all very subtle, but she definitely is.
that
May
is
I read the provision? Would you
information.
like me to read the
All
provision?
right, everybody, please slow down and stop. She can't record all of that like the way you're talking right now. Mr. Best, please read what she's reading from as to whether arbitration is required.
Yes. If either you or we make a demand for arbitration, you or we must arbitrate any dispute or claim between you or any other user of your account and us, our affiliates, agents, and or dealers, merchants, retailers that accept the card or program sponsors it relates to your account, except as noted below. Basically, the noted below is the small claims provision, standard language, but the arbitration is elective. It's not required.
So I am requesting that the court compel this to arbitration because it says in 9 USC that the court, for staying the court proceedings when an issue is referable to our arbitration. If a lawsuit is filed on an issue covered by an arbitration agreement, which there is one, okay, the court must stay, it says must, the proceedings and compel arbitration if the issue is properly referable to arbitration. So it does not say I have a time limit to, unless you can show me where it says that I have a time limit to request an arbitration.
Michigan case law is very clear about waiver.
So everybody stop. So
Okay.
Ms. Grady out, give him one moment since you didn't receive it. So we didn't address that issue. Her issue is that she never got the reply brief, but I want to handle this today. So I want to say that it was filed with the court on May 20th. Today is May 22nd. And I don't know whether, let me see, where's the proof of service on this? One moment.
And I am consistently, when I file paperwork, giving them notice of at least about 2 weeks or close to 2 weeks. And repeatedly, they are sending information to me at the last minute. And it is obstructing. It is obstructing proper defense on my side because they are repeatedly, every single time they are sending things to this address at a late notice where there's only a couple days for review. I am sending it in enough time for them to view it, process it, and respond. They are not. They're being deceitful. They're not being honest.
So it looks like, Mr. Best, your office didn't put this in the mail. So you brought it to the court, apparently. It was dropped off. You brought it to the court and dropped it off on the 20th, but you put it in the mail to her on the 19th. There's no way possible she's going to get that in.
We mailed it to the court. We received hers. Bear with me.
It was mailed on the 12th. Mailed on the 13th. Let me look at my receipt. I do have my receipt right in front of me.
His point, though, ma'am, is if you mail it to them on the 13th, by the time they get it and have time to respond.
We literally turned it around in one day, Your Honor.
Yeah, it's going to have a very short turnaround time, regardless. But this is not folded, so I think your office delivered it to us, Mr. Best. There's not, it could
Let
have
me
been put in
double
one of
check.
the.
I don't believe that is correct.
Well, I don't think
I
it's
think we
possible that it
mailed
could. Well, then if that's the case, I would have an issue because you mail it, it's not gonna get to us. If you put it in the mail on the 19th, it's not gonna get to us on the 20th. That's not
Yeah,
a,
we sent it overnight, FedEx.
okay. Did you send it overnight FedEx to her?
We sent defendant first class mail.
So she's not gonna get it, so she doesn't have it. So that means, Mr. Best, that you need to read the case law that you're citing to her so she can at least hear what you're saying is your argument, because she doesn't have the document.
Very good.
So again, I would have no time to respond. I am not an attorney. I don't have this terminology in defense.
Gradial, Miss Gradial, Miss Gradial, Ms. Gradial, I'm very, very aware of that. So please understand that I'm taking that into consideration, okay?
Thank you.
Okay.
Mr.
And
Best,
do you want me to read the germane paragraph, Your Honor?
correct.
Okay. The presence of a no waiver clause to arbitration does not alter the ordinary analysis undertaken to determine if a party has waived its rights to arbitration. Citing to S&R Company of Kingston versus Latana Trucking, Inc., 159 F. 3rd 8086
reading
at
from?
page 86, Second Circuit, 1998, cert
Wait,
denied
whoa,
528 US
Mr. Best,
and 58.
Mr. Best,
Yes,
where are you reading from?
I'm reading from page 5 at the very top. I went to the actually I could go back a paragraph if the court.
Well, it's not numbered, first of all, but you're reading from page 3?
Yeah, I'm sorry, page 3, let me start at the bottom of page 2.
Okay.
Okay. Unless the court would like me to start somewhere else.
No, that's fine.
Okay. In presenting a motion to compel arbitration, the moving party must do so without, 1, taking actions that are completely inconsistent with any reliance on an arbitration agreement, and 2, delaying its assertion to such an extent that the opposing party incurs actual prejudice. Citing to Hurley v. Deutsche Bank Trust Co. Americas, 610 F. 3rd 334 at page 338, year 2010. It does identify a quoting case, and then it also identifies to see General Star National Insurance Company versus Administratia Aseguilar Distrat at 289 F. 3rd 434 at page 438, Sixth Circuit, 2002. Goes on that the presence of a.
Mr. Best, let's stop there.
Okay.
What is the actual prejudice to you?
We have spent a considerable time and effort briefing, appearing at hearings. We've engaged in litigation. That's all held for naught if the court now refers this to arbitration. That's valuable time wasted, including the court's time. And I believe we are definitely severely prejudiced in the number of times we've appeared before this court.
I would have to respond that I am also incredibly prejudiced because information I have asked for and the plaintiff has supposed to sent to me in a timely manner has not gotten there. I've too had to appear at these appearances. I too had to take time to do research, probably more than the plaintiff, because I don't know all the terms. They have an upper hand. So I too have been very prejudiced. And then the plaintiff is trying to prejudice me even further by asking for finances that they have not yet or failed to prove that they actually deserve. The plaintiff has repeatedly, because the defendant does, I believe, in my opinion, does not have an attorney, has taken advantage of this situation or attempted to take advantage of this situation by not giving information late, and also filing, not responding how they should. I asked for specific information to even prove a contract between the two, not giving it. You were told by the court to send some unredacted documents that you put on public forum for people to see. It was placed on public forum, unredacted documents that should not have been. Those should have come to this address.
It was submitted as court records, and the court puts it as public material. That's what happened. They didn't upload it to something and make it public. The court made it public.
So in your speaking of anybody being prejudiced, that would be the defendant is grossly. And I ask that the court compel this to arbitration, which is where it should have been in the first place.
Your Honor, I can only point out that the clause was attached to the complaint. The clause was, the arbitration agreement was attached to the complaint. So I have no idea what defendant is complaining about.
And I too said,
Well, everybody, please stop. What she's complaining about is the fact that when the request was made by her to get a copy of the documents that proved that this was a valid contract, her personal information was included mistakenly by your office with the documents that came to the court, as opposed to the documents that were supposed to go to her. They came to the court and were placed in the public file. So that's the prejudice that she's referring to.
Okay. And I would move to have that stricken.
Right, I understand that, and we will strike that. We've already instructed the staff to do so. But that's the argument she's making as far as that part is concerned, because she wasn't able to see the actual account to be able to know that it was her particular account. That has been something that she has stated from the very beginning. The second hearing that we had to have was because the documents were FedExed to her shortly before the hearing that we were supposed to have, and she had not had time to review them because she was out of town. The first hearing that we had was at the court's request for the matters to be briefed more thoroughly, because she had filed responsive pleadings and no one had briefed every single one of her responses so that we could have an actual hearing on each one of those. So there has been a lot of litigation. I understand that there has been a lot of litigation, and Miss Shatina Grady-L, Mr. Best is correct. The concept of an arbitration as it was indicated in this particular contract is one that is elective, meaning that a party has to elect to have it. They're not precluded from coming to court in this particular case, and they were not wrong for bringing this case to the court. However, you have now made a demand for arbitration in this case, and so as I see it, and Mr. Best can choose to appeal or do whatever, but as I see this, the issue before the court right now is whether or not there has been an extensive amount of litigation to the point that the plaintiff portfolio is actually prejudiced by that. They have expended a considerable amount of time coming back and forth to court here, but that does not, in my mind, equate to necessarily a prejudice. I am going to grant your request to compel this to go to arbitration. But what that means for you, ma'am, is you need to file the documentation to go to arbitration. I will stay it until you do that. I'm going to stay it for 30 days. If you do not file that in that 30-day time period, we will come back here and there will be no more requests. Okay?
yeah.
So you need to file the monies and go to arbitration. The motion to compel arbitration is granted.
Thank you.
Thank you, Your Honor.
You're welcome. Ms. Grady, are you gonna prepare the order for that?
Yes.
Well, do you want her to prepare it? You guys don't even talk to each other.
Your
so-
Honor, I have a standard order I can have prepared and submitted.
Thank
Do
you.
you have her email address?
Okay, unfortunately, that's where the hearing cut off. I wish that they would have continued after that point, and you will see why in this hearing.
All right, the court will call the matter of Portfolio Recovery Associates LLC and Shatina Grady. 24C 2622.
Thank you. Good afternoon, Your Honor. Daniel Best, P58501 on behalf of Professional Recovery.
Thank you. Please state your name, ma'am.
Shatina Grady.
Thank you. All right, the last time we were here on this particular matter was back on May 22nd, 2025, when I granted Ms. Grady's request to stay this matter and compel arbitration in this case. And it was set for a review today to determine whether she had filed or we were moving forward on the MSD.
So I come today to have my motion for dismissal requested. And
Ma'am, what happened with the arbitration?
So there was no arbitration because that attorney that took the information mysteriously emailed it to the wrong email. I called them on May 23rd, on June 9th, because I had checked my email. If you will recall, at the end of that last court date on the 22nd, the attorney that spoke or sat was supposed to send me information regarding arbitration. I checked the email every single day. There was nothing. On June the 9th, I called to find out why I had not received anything, and I had to leave a voicemail. I did that. I called on July the 1st to find out why I had not received anything and what is going on, because I'm still checking the email. Nobody's called me back. Nobody has reached out to me by mail, nothing. On July 2nd at 8:37 in the morning, they had a representative call me. When I spoke with Kelly at 3:02, finally getting in touch with someone, she said, even though this attorney at the last meeting repeated the email back to us, managed to misspell the email when they sent out the arbitration stuff. So as of today, when I checked, I still have no arbitration stuff, because on the 2nd, when I spoke with Kelly, I gave her the corrected email. I don't understand why this firm is unable to get me the information that I need, either not at all or in a timely manner. I don't understand why, when they can repeat back to me what I have given them per the email, that mysteriously one letter gets changed. So arbitration has not gone through on the failure of their behalf.
Mr. Best, response?
Thank you, Your Honor. I was that attorney. I repeated back the email address that was provided by defendant. I reiterated the E because it was not her last name. I mean, not her first name. It was Shantine, not Shantina. And I got confirmation. I completed the order, and it was an order of stay. There was nothing in that order that would preclude defendant from seeking the arbitration as was ordered by the court. So the email that was sent was not returned undeliverable. We did not have any notice that there is an issue until yesterday when my staff returned the call. Admittedly, we did receive ISHO on June 10th a call that was misrouted by my receptionist and was not returned. But the bottom line is, at that hearing, the court gave defendant until today to initiate the arbitration. Nothing in that order was needed by her to initiate the arbitration, and the arbitration was not initiated.
So in response to that, at the last court date, I spelled out SHATINA G 317, and I said G for Grady, right? And so you repeated that back to me. First, you asked if it was the E, because in the new name, it is SHATEINA. And I said, no, it's not. You asked me, was it going to be spelt that way? Because it's different from what, and I said to you, no, not to that name. We're not spelling it that way. We're not using the E. I specifically said we're not using the E in Shatina, SHATEINA. And then I also said G for Grady, 317 at Gmail. But the email that you sent it to, if I'm telling you there's no E from what you see on my sign-in, SHATEINA, because that's what's on my sign-in, I told you to omit that E. That doesn't go there. We're going to, it's spelled the way that it's in the court papers that you filed suit of, if it's in front of you, you filed suit for SHATINA, okay? And then Grady. And then as to what you sent me, and you saying that the court said that I had to do, if I want to seek arbitration, she asked me, did I know how to do that? I said, no, but I could figure it out. You said, well, I can send an email. Whatever your specific words, which is why I'm getting transcripts printed. I don't know what your specific words, but you cut in and said that you would send me the email. That's when we got to the email aspect of it. That's how we got to the email aspect of it, because I had said, she asked me, did I know how to do it? I said, well, no, but I can figure. And you said, well, I can send, you said, I'll send an email, or whatever your wording was. You didn't say anything about sending whatever you just said that you were going to send. So again, you're playing games, and you're being dishonorable, you're being deceitful. You have not
Miss Grady,
yes.
please stop going down that line.
I'm just telling you.
Miss Grady,
I'm
the
just telling you.
reality is that you came in here and you asked for an arbitration.
Yes.
And I stayed this matter and gave you an opportunity to file that. So,
But he also said, when you asked me, Judge, you asked me, and if you needed to run the transcripts back, we could do that. You said, do you know how to do that? I said, no, but I'm sure I could figure out. And he said, as a cut-in, that he has a packet that they normally send out. Nor not I have received that packet, but I didn't receive an email for it. I knew that I would probably not get any response until close to the court date. Like, I knew that. That's why I even called on June the 9th. That's why I even asked if there was a note I could send you at the court. And I was told no. I knew that they would try and do this, that their people called me just now, yesterday. And if the court rules in his favor, I'll just have to appeal it, because there's nowhere have they been honorable in trying to get this squared away. And nowhere that they have a lack of transparency, a lack of due process, because they either haven't given me the stuff on time or not at all for me to present an effective defense.
Ms.
And if
Grady,
the court
Ms. Grady,
understand.
I've adjourned this case, I don't know how many times, to give you an opportunity so that you can be prepared. So
And
please don't interrupt me. Please do not interrupt me, please. Today we're back here, and I'm not happy with either side. Because one, Ms. Grady L., if he didn't send you the information, you could have done what you said you could do, which was figure out how to proceed with the arbitration. And Mr. Best, on this particular case, at each and every turn, there's something that comes up that doesn't go right, which complicates this matter even further. So if she's calling you guys, and now with that particular call, it gets rerouted, and like she said, she doesn't get the call back until yesterday. And as far as an appeal, appeals don't scare me, Miss Grady. I don't mind that people appeal. That's for a higher court to decide if I've done something wrong. But I try to do my best to do the right thing by everybody that comes before me. And I've given you many opportunities. So, Mr. Best, I don't recall the specifics of that part as to whether there's a package.
I have no package, Your Honor. I have no packet. I have, and what I agreed was I would provide the order granting, or that's what I believe I was agreeing to provide, was the order granting defendant's motion. It's normally the party who brought the motion's obligation to do the order. My remembrance was she did not know how to do the order, and I agreed to do the order because I have a standard one that we do on these cases. I would never agree to provide legal advice to a defendant on how to file an arbitration. I do recognize that my office did drop the ball with respect to the order and getting it to defendant, but I insist that the information I took down is what defendant provided. Granted, we did not properly follow up and we did not properly respond to her voicemails, but it's strictly the order.
And in reality, where we are right now is this court doesn't have an order in it referring it for arbitration or a stay or any of that, because the order was never submitted to the court either.
So what I would propose is that we provide, I believe it was 45 days originally. I don't want to keep kicking this out, but we go out 45 days, which would roughly be August 18th. And that she file it by then. I am not providing her any instructions on how to do so. I will submit the order under 7-day.
So we are all clear, Ms. Grady L. He's submitting the order that says that I granted a stay and that you are to file your arbitration within that time period. It will not say anything else or provide any packet for arbitration. It will be your responsibility to figure out how to file your arbitration. Okay?
I hear you, Judge, but I would ask for a dismissal.
That's not how this process works, Ms. Grady L. And you can file whatever motions you want to file around that.
I feel biased upon.
Okay, then you can feel however you want to feel about that, and you can file whatever you need to file.
Your Honor, if I can, I'm actually out of town the 18th and 19th of August. I would like to be the attorney who handles this. Could we schedule that either? Yeah, I got a dentist appointment on that Thursday. Does the court hold these strictly on Thursdays?
Strictly on Thursdays, and the 18th wasn't an available date anyway.
Right, the 21st would be the available date. I do have a 1 p.m. dentist appointment, but if we could go, I have a very good dentist. If we can do it at 3 o'clock again, that would work.
We're not here on the 21st. He's not asking for that. He's asking for the next date, the 28th.
Okay, I'm sorry, I'm just wasn't sure if you had originally given that.
No, I did not.
Number of days.
So counsel, you're gonna submit the order granting the stay and providing her with 45 days to file her arbitration. And
Correct.
that be submitted under the 7-day rule. Ma'am, the 7-day rule provides that once the order is submitted, you have 7 days to provide any objections you may have to that order. Court date will be scheduled for August 28th, 2025 at what time, please? 3:00 p.m. This is the last date for that arbitration to be filed. If it is not filed, once again, I will tell you, your MSD will be heard that day. His MSD will be heard that day if it is not filed.
And just for clarification of the order, is it 45 days from today's date, 45 days from the entry of the order, or by August 28th?
Let's just make it by August 28th. When we come back here, that arbitration needs to be filed.
Very good.
Thank you.
Thank you. Have a good day, everyone, and a happy 4th of July.
Oh my gosh, that was so much fun. Oh my goodness. Oh, the subtle clues of the Moor. I'm surprised we didn't hear anything about her trust or about maritime law. The Moors are kind of, I don't know if they have different like sectors or how that works. They some of them adopt certain practices and some of them adopt others, but just generally overall, it seems that getting out of paying for what you owe for things, I mean, that's just standard across the Moor board. Oh, I was happy to do it. I had so much fun editing that one. It like I said, other than the February hearing taking like 5+ hours to edit, it just still I had to. I just love that. That's why I do what I do and collect the dockets every day, because I can then do stuff like this where we get the full context. Otherwise, just if we would have just saw yesterday's hearing, we would not have realized what a bungling mess that law firm is. And it really is. That was the first comment. I missed it and I only saw Morty's. Yeah, something like that. I've already been working on tonight's. So yeah, I am planning on coming back tonight. I am planning on it. So yeah, I mean, you probably already figured it out, but Judge Washington is part of tonight's. I came across that one and I just had to go back and find the others and slop them all together. I am so happy you were here to celebrate it with me. I appreciate it so much. So does Ava. That means she gets, double the treats today. And Ava's all for that. All right, guys. I am going to get back to editing because that's the only way I'm going to get it done. Thank you so much for coming and spending your 4th of July afternoon with me. And I look forward to seeing you guys all here tonight. Be safe, be well, stay sweet, and much love.